Andrew, it's good to see you. We're together here today to talk through some issues that we're seeing in the ERC space, specifically to PEOs, professional employer organizations. Before we launch into a little bit about you and your practice, I'll mention that my background is as a tax attorney, primarily in tax controversy work, meaning anytime there's a dispute with the government about something related to taxes, from audit to collection to white collar to any sorts of disputes related to taxes. Our firm has gotten involved with the employee retention credit early on. And while we were doing some filings for taxpayers and eligible employers, we started to identify issues that maybe Congress didn't think through, or the program rules leave a little bit ambiguous. And over the years, the IRS has weighed in on some of these issues. But front and center right now really is issues with professional employer organizations. And I know that you've had some experience with that. So maybe you could share for us a little bit of your background and also some of the frustrations that you're experiencing with those PEOs.
Yeah, thanks, Peter. As always, good to see you. Good to chat with you. This is certainly a interesting topic. By way of background, I'm a partner at Burnett Injury Group. I've spent my career as a trial lawyer in courtrooms, whether it's where I started my career prosecuting criminals to then defending cases in civil litigation, and then now for the last almost 10 years prosecuting civil cases. And as you know, we've teamed up for a while here on these ERC issues because this is a extraordinarily complex program and it seems to have a ton of issues, especially when it relates to the PEOs. I'm talking to businesses almost daily throughout the country where they just have a complete lack of transparency on what's going on with their ERC claim because they were required to file through their PEO and they're relying on their PEO for that information. And a lot of that information is not forthcoming, and it's causing a lot of concern for a lot of businesses that this program was designed to help American businesses during an extremely difficult time. And, here we are 5 years later, and these businesses, not only do they not have their money, they can't even get the information about what's going on with the ERC money from their PEOs.
And it's just a tremendous power imbalance, I think, between what a taxpayer who has been working with a PEO and what they're able to figure out on their own versus having to rely on that PEO relationship and that service agreement that they have entered into potentially years before anyone contemplated ERC, and they're sort of stuck in that sandbox, right? And it's presenting some really interesting issues.
Yeah, I agree. I mean, I think the biggest issue with a lot of this is the lack of communication. This is certainly right in your wheelhouse. As you know, the individual businesses can't call the IRS to say, hey, what's going on with my ERC claim if they file through a PEO. And the PEOs appear to be, not having the incentive to give their business owners any information as it relates to what's going on with their PEO claims. I mean, I've spoken to businesses throughout the country where they can't get the PEOs to even respond for anything. They just say, there's no information. We can't provide you with information. And that's not really true. My understanding, and based on discussions with you and the research we've done, there are things that PEOs can do to provide the information. They're just simply not doing it.
Yeah. And if anybody's watching, out there, that sounds totally wrong, right? That a taxpayer, someone paying these taxes, albeit through, another organization, can't go to, their government and say, can you confirm that X, Y, and Z has been filed, that I've made this claim, that you're working on this, for me. Rest assured, the federal government, the Internal Revenue Service has come out with what's called a generic legal advice memoranda and confirmed, their position that really the PEO, a CPEO, a reporting agent is the entity that they're going to deal with. And the customers of these entities are not the ones that can go to the IRS, that can work through these issues. And so, yeah, I mean, I mentioned earlier sort of moving from the theoretical to the very practical right now. There are things that PEOs can do to work with their customers to show their work a little bit, unfortunately. And Andrew, I'm curious your specific experiences, but that's not always forthcoming. And it sometimes takes someone to shake that loose a little bit.
Yeah, for sure. I mean, we're seeing, in addition to the lack of communication, I think there's three main buckets of issues that we're seeing businesses have as it relates to the PEOs. The first bucket is PEOs that failed to timely file the ERC claim on behalf of the business. So if your business qualified for ERC credits for any quarter in 2020, the deadline to file that claim was April 15th of 2024. Now, Peter, and maybe you can talk to this a little bit later, but there may be some legislation pending or ways that Congress may retroactively change that so that the deadline was actually January 31st, 2024. But at a minimum, we know that if claims for 2020 quarters weren't filed by April 15th of 2024, those claims are no longer able to be filed. And that's a problem both for the small business that is entitled to and needs that money if they qualified, but it's also a liability problem for the PEOs. And those PEOs that failed to do their job need to be held accountable. The second issue that we're seeing is, and there are some lawsuits pending around the country currently, is where a PEO did the filings correctly. The government paid the ERC money to the PEO. The PEO then paid it back to the client, but the PEO wrongfully withheld the interest. So again, this is something that's you can speak to, but we know that there's statutory provisions that say that, if the claim is not paid within a certain amount of time by the government, that they're due interest on that ERC claim. And we're seeing there's lawsuits pending in other parts of the country where the PEO just kept that interest money without any conversation, without any agreement. And so we're seeing claims for civil theft, unjust enrichment, conversion, just sort of depends on which jurisdiction you're in, but we're definitely seeing that as an issue. And then the third issue, the third bucket is PEOs not timely transferring the money to the business after the government has paid it. So there are multiple large PEOs out there that we know and we've seen that are getting money from the IRS. They're putting it in their coffers, and then they are sitting on it and not timely transferring it back to the clients with or without interest. And that's a problem because the business is entitled to that money, not the PEO. And so for the PEO to sit on it, especially now in 2025, when these funds were designed to be paid out years ago, these businesses need that money to keep operating. And that was the whole point of the program. So to me, those are the three big areas that I'm seeing in terms of litigation that either I'm a part of or I've spoken with other attorneys throughout the country. And it's pretty universal among a lot of PEOs, unfortunately.
And that last bucket with sort of retaining the funds, it may be a fine line because you've got situations where the IRS has certainly said, look, in most circumstances, a PEO can be liable for these taxes if inappropriately paid. And so you see PEOs where they are demanding from taxpayers additional substantiation. You're seeing situations where PEOs may take one position related to eligibility and aren't thinking through any number of other situations where the ultimate taxpayer, the customer of the PEO is an eligible employer for purposes of the credit. So I anticipate there being some disputes about that and about the actual analysis there. The other thing that when the government came out with their GLAM, their generic legal advice memorandum, they made very clear that if the PEO itself owes taxes, that these credits can be used to offset any liabilities there. I would anticipate, and Andrew, I don't know if you've seen any of that, something similar to that going on, as well.
Yeah, you bring up two really good points there. The first thing that you mentioned is the substantiation. From my perspective as a trial attorney, I agree with you that the PEOs do have an obligation to substantiate the claims because of that GLAM. But number one, they should have done that before they even submitted it. And number two, there's got to be a threshold in terms of what is a reasonable time. And to me, what I've been telling clients and the things that I've been seeing, that's a red flag for me when all of a sudden, out of the blue, the PEO is now making the clients jump through a ton of unnecessary steps, especially when a lot of these businesses provided the substantiating information on the front end. And now the businesses are saying, we need additional surveys filled out. We need statements justifying all the reasons under full or partial governmental suspension or shutdown order, and just one thing after another. I've talked to a couple of clients recently where the PEO says, okay, we need X. They provide X. Then weeks or months go by, they say, we need Y, and they provide Y. And it's just one hurdle after the other, when it either should have been done on the front end or there needs to be a reasonable time frame. And, I think these are things that businesses, if they're having those problems, they need to take a deeper look and have somebody take a deeper look. And then in terms of the second point that you raised, in terms of the offset, if the PEO has a tax liability that the IRS is sort of applying it to the PEO tax liability, we have seen some of that as well. I mean, in the last couple of years, there's been a couple of PEOs out there that have been on an acquisition spree and incorporating or purchasing a lot of small and mid-sized PEOs, and those PEOs may or may not have tax obligations to the IRS. And so we have seen some examples where the PEO timely filed the ERC claim on behalf of the business, the IRS processed it timely, but instead of returning the funds to the PEO and then subsequently to the business, the IRS kept it and applied it to an outstanding tax obligation of the PEO. And that's a problem. And that's going to subject PEOs to liability.
Yeah. And I guess we're not totally unsympathetic to, what has been going on to PEOs. This has been challenging. There's no question the sort of regime for this reporting and how it works is really hard. And I don't know that Congress necessarily thought through all of the nuances with it, what they were truly asking of PEOs and CPEOs. But, it's 2025 now, right? It's not 2021 when this first came out as a response to the pandemic. It's not even the end of 2020 when they sort of opened up ERC to broader eligibility, or early in 2021, after which time, Treasury certainly made clear that these filings are done through PEOs, and they put out these GLAMs and they put out this information. It is well into 2025, and taxpayers do not have answers that they are in need of. And frankly, they are reaching out in very strong numbers because they're really getting frustrated.
Yeah, and you beat me to the punch on that, because I would agree with you for a short period of time that, some of these PEOs, we got to give them a little leeway. This is, one of the most complex IRS programs that's ever been put out. There was a lot of confusion about it initially, but we're in, like you said, it's 5 years later, and that's way too much time to have passed for the PEOs to not understand what's going on. I mean, I just talked to a client yesterday where the example of the continuous hurdles that are put in place, those things should have been done years ago, not now, when we know that they're sitting on the money for the business, and the business really needs that money. I mean, you guys are a perfect example. You and all the other members over at Frost Law were early adopters. It was a complex program, but you guys got up to speed super fast and got well versed in it. That's what all of these PEOs should be doing, because keep in mind, most businesses that are using PEO services are paying a premium to that business. It's not just a payroll service. They're paying above and beyond normal payroll service for these PEO services. So if you're paying a premium for service, you kind of need to get that in return, premium service. So yes, I have a little, leeway for the PEOs, but that's pretty much come to an end, given the fact that we're 5 years in at this point, and we're still seeing problems, and the problems are numerous.
So I guess it's one thing for, me to talk about some of this stuff as a tax guy, deep in the weeds on, Title 26 and tax code. What is it that a litigator can help to do, when it comes to issues with PEOs, employee retention credit generally?
Yeah, good question. Our process is generally, once we vet the client and the underlying claim and make sure everything is the way it should be, we're sending demand letters to PEOs and asking for the proof of filing. We're asking for things like the Schedule R. We're asking for the IRS tax transcript to show when the claim was submitted. And we are getting mixed results from PEOs. Sometimes we're getting some compliance. Sometimes we're getting totally stonewalled. In the event that we get stonewalled, then we're filing suit. I'm involved in some litigation involving ERCs, money, and PEOs, where here we are in 2025. The lawsuit's been ongoing. We're filing motions for documents. We're having to ask the court to intervene and compel them to provide these simple documents, and they're still not doing it. To me, that is extremely concerning, because these are not that difficult of documents to obtain, yet the PEOs aren't providing them. So the question becomes, why aren't they providing them? So those are some of the general steps that we take. We send initial demand letters, and if we can't get information, then we're filing suit and we're moving forward to hold these PEOs accountable if, in fact, they failed to do what they were supposed to do, or they're wrongfully withholding interest or clients' funds.
Sure. And I mean, you mentioned it earlier, so we should flesh it out a little bit. And to some degree, you're racing toward a deadline right now if it's related to a 2021 refund claim that hasn't been filed. But there is still the challenge of, what if Congress comes in and changes the rules, as they have tried to do not once but twice before, to say that the due date for all of ERC is not actually either April 15th, 2024 or April 15th, 2025. It's actually January 31st, 2024. And what that may look like for all of this, because I've seen memoranda from the House Ways and Means Committee. Certainly reference to ending ERC early is on there. It may be very attractive because it's already been scored between $70 and $75 billion. And as the new administration tries to get their policies in place and deal with TCJA sunsets and provisions that they want to extend, could be a very real possibility that they try to retroactively end this program.
Yeah, and I think there's a lot of uncertainty about what the government may or may not do. Certainly for businesses that I've spoken to, I'm, telling them they need to act immediately, if not sooner, in regards to making sure their PEOs have all the filing documents that they need. If there is a change in the law and the cutoff for when ERC claims can be filed, that's going to create a lot of liability for PEO companies, because I've talked to so many small businesses where they have told me that they provided all the documentation that the PEO requested as far back as, the beginning of 2022. And then they're getting mixed information from the PEO itself as to when it was filed. To me, as someone who holds businesses accountable for negligent actions, if you sat on documents that your client gave you, and you didn't file it for 2 years, and now because of a retroactive act of Congress, you've missed the deadline, I think that's on the PEO. I mean, part of our job is, Peter, is keeping our clients informed and making sure we're moving things along and moving cases. I mean, if you or I were to get documents from a client and sit on it for 2 years, we're going to have problems ourselves. So there's no reason why these PEOs shouldn't be held to the same standards of timely and efficiently acting on behalf of their clients.
Yeah, so this has been really helpful. I mean, in my practice, I'll be out there talking to CPAs or to taxpayers and say, this is a good time to make a referral or to come and talk to me about something related to your case. I think this has been really helpful to take us from sort of the theoretical stuff that we can imagine is happening with PEOs in the ERC space, but now better understanding, well, when does it make sense to get a litigator involved, someone who can advocate on behalf of these taxpayers who are having issues with their PEOs.
Yeah, no, I mean, it's always a pleasure to talk to you. It's super informative. You've always been on the forefront of all things tax and ERC. And, some of these red flags that we discussed today, if businesses are seeing these red flags, then they need to talk to an attorney and figure out what is the next steps. And sometimes it's simple and sometimes it's complex, but each case is different and unique. And you need to have somebody who's been dealing with this for quite some time look at it, evaluate it, and give you information as to the next best steps, because some of these businesses are looking at very large sums of money that may or may not be coming to them now because of failures by the PEO. So they should talk to somebody who can help them understand the nuance involved in all this ERC PEO business.